All right, welcome back to Wills. And today we're going to be looking at the organization of a will, the various provisions of a will, and some terminology. The textbook really lays this material out in much more detail. This is only intended to be sort of an overview. All right, so we remember from our will requirements that there are statutory formalities, is what we are looking at now. The intentionalities will come in Chapter 8. The writing, the signing, and the witnessing, keeping in mind the disinterested witness rule, and from Morris v. West, the presence requirement, making sure that if someone else is signing the will for the testator, that the testator is in the physical presence and it is at the testator's direction. All right, so in terms of testate succession and issues, you will either be told, that it's a document, or you will be told that it is a duly executed will, in which case you need not go through these formality requirements. So make sure you spend a little bit of time paying close attention to the facts. Unless otherwise indicated, unless you have some facts to work with, you may assume that the testator has capacity and intent. Watch for distractors like attestation clauses, self-proving affidavits, failing to write their full name, not putting their address, or initialing. Those are some extra things, extra steps that are taken, but they are not a requirement. Keeping in mind the statutory formalities are in the jurisdiction of domicile as of date of death. All right, let's take a look at the structure. The structure of a will is going to be broken down into dispositive provisions, those giving property away, non-dispositive provisions, and fiduciaries. Now, that's the way this lays out in the book, but it doesn't mean that that is the way that this comes to you in the form. You need to make sure you take a look at the form in the appendix so that you're familiar and you can recognize these various provisions. Parts of the will, again, take a look at the back, opening statement, dispositive provisions, fiduciaries. Think about what you need to be able to look at a sample will and recognize the provision that it is. Identify the provision. We're going to be speaking first about the dispositive provisions. What are dispositive provisions? Well, they are the provisions of a will that matter, that give the property away. They can be identified as specific, either specific in nature or general in nature. Specific in nature is my 2023 XT5 Cadillac. General in nature would be my car. Okay. Demonstrative is a cash bequest funded from a particular asset, 15,000 from the sale of the boat. If the boat exists, you are protected to the extent of the boat, and then general to the extent not. A general bequest is a bequest of cash. It does not matter if the estate has cash. You can always liquidate things and make cash. A residual provision is a catch-all, everything else. Every will should have a residual provision, even if it attempts to give away every single thing that the testator has. And that's because just because you have a will, you don't stop living. You acquire and sell property after that point, hopefully. All right, so let's talk about these different bequests. I give 808 Main Street to Mary as a beneficiary. At the time that I prepared the will, I happened to own 808 Main Street. During my lifetime, I sold Main Street and I purchased Shore Road. Rest in peace means at date of death, I owned Shore Road, 456 Shore Road. I no longer owned 808 Main Street. So what happens with a specific bequest of 808 Main Street to Mary is that it adeems. There is no replacement. The UPC has a little bit of a different rule, but the risk of having something specific in nature is that you may not have that asset at date of death, and typically there is not a replacement. You don't trace the proceeds of 808 Main Street to 456 Shore Road and give the beneficiary 456 Shore Road. My principal residence, specific bequest, general in nature. So to the extent that I have any principal residence at time of death, the beneficiary will take. $50,000 to be funded from the sale of car to Bobby, demonstrative. Yes, at the time that I wrote the will, I had $50,000 in cash. I spent it. I didn't have it at the time of death. Doesn't matter. A cash bequest of $50,000 can be funded with anything. We could sell the house to generate the cash as long as the house has not otherwise been specifically bequeathed. $50,000 from the sale of the car, right? We have the car, then we sell the car. We might get $40,000. The other $10,000 comes from the sale of the house. Residual, everything else. You have to be able to identify and recognize what a residual bequest is. Non-dispositive provisions, sometimes boilerplate. Opening statements, important that we have a revocation. Funeral, you might allow the personal representative to go beyond the statutory limit. Taxes, we saw in the Ferguson case how that was a problem. We can create our own definitions. We might want to draft around simultaneous death. Inter aram provision is a provision that deters people from challenging the will. You have to give them something to lose. And intentional disinheritance, not necessary, but some people find it, some people use them. I've intentionally not provided for my brother Joe because he has enough money of his own. Exoneration. What property is subject to a lien and who pays the debt? An estate or a beneficiary? If when you analyze the assets of the testator, you find that there are assets that are subject to liens, whether it be a car or a house, then you have to understand the rules of exoneration and carry out the testator's intent in determining whether or not the testator wishes for the property to pass subject to the lien, or if the residual estate will be used to pay off the lien and allow the beneficiary to take it free and clear. All of that can be handled in the exoneration provision of a will. What about the tax provision? Do you want a tax provision? And if so, who's going to pay the tax? Someone's going to pay the tax. Is it going to come out of the residual, or do we want the beneficiary who is receiving the property subject to the tax to pay the tax? Fiduciaries. There are essentially three fiduciaries involved in estate planning. Either the executor or personal representative. Every will has or needs a personal representative. Secondly, if the testator has minor children, there may need to be a guardian appointed. The natural parent of the minor child is automatically the guardian if one parent dies, but what if they both die together, or what if the other parent has previously died? In a complex will or a will with a trust, we need to also name a trustee. So those are the fiduciaries that you need to become familiar with, and they will be used, keeping in mind if you are a fiduciary, you owe a fiduciary duty to someone. So when I call someone a fiduciary, that automatically imposes fiduciary duties on that individual or entity, right? You could have a corporate personal representative or trustee, you could name your attorney, etc. All right, so we are going to be digging into the provisions of the will. What about safekeeping? After the will is prepared, you have to meet with your client if it's an in-person execution, or today you can do it electronically, to make sure that they understand the provisions of the will. Ask them if they would like the respective witnesses to witness, and then don't be distracted. No phone calls, because it's very easy to make a mistake during the execution ceremony. Bring your witnesses in, and have the testator initial every page. Again, that is not a formality, but just an additional precaution. And then date and sign, followed by your witnessing. What's going to happen with the original will is also an important thing, because an original will must be located upon death. Some safekeeping options are with the testator himself, leave it with the attorney, a safe deposit box, or for a small fee, the register of wills. If the original cannot be located, you must petition the court to admit a copy. So that is not a desirable thing to have to do. Okay, see you next class.